Welcome to the deep dive. If you're in Virginia and facing a Social Security disability hearing, you've definitely landed in the right place today.
Yeah, we're here to try and cut through some of that uncertainty.
Exactly. We want to give you a real sense of what to expect so you can walk in feeling, prepared and a bit more confident.
We've been looking at advice specifically for Virginians, and the goal is pretty straightforward, really.
Just to arm you with the knowledge you need to handle your hearing effectively.
Absolutely. Walking into that hearing room can feel, well, pretty daunting. And feeling unprepared just makes it worse.
We want to demystify it a bit, focusing on those questions you're almost certainly going to hear, and offer some insights on how to approach them.
Let's do it.
Okay, so first off, let's paint a picture. People might imagine a big courtroom like on TV. What's the actual setting for an SSD hearing here in Virginia?
Yeah, forget the courtroom drama. It's much less formal. Think a comfortable conference room, usually.
Okay, smaller scale. And who's typically in that room with you?
Right, so you'll have the administrative law judge, the ALJ who makes the decision.
Okay.
There'll be a hearing assistant helping the judge. And then, depending on your case, you might have a vocational expert there.
Someone who knows about jobs and work requirements.
Exactly. Or maybe a medical expert to talk about the medical evidence. And of course, if you have an attorney, they'll be right there with you.
So it's this group all focused on figuring out if you qualify for SSD benefits here in Virginia. How long does this usually take? Are we talking hours?
Not usually, no. Typically, you're looking at maybe 45 minutes to an hour, sometimes a bit longer if it's, a particularly complex case.
Okay, 45 to 60 minutes. Now, here's a stat that really stood out to me in nearly half. About 46% of claims actually get approved at this hearing stage.
That's right, which really underlines why being prepared is so critical.
It shows this hearing is a real opportunity.
It absolutely is.
Okay.
How well you explain your situation, how clearly you answer those questions, it can genuinely impact the outcome. Knowing what's coming helps you think through it beforehand.
Okay, so let's dive into those key questions. The first one seems pretty fundamental. Can you describe your medical conditions and symptoms? This isn't just listing diagnoses, is it?
No, not at all. This is usually where the ALG starts. It's your chance to explain, in your own words, what's going on and how it affects you personally. It really lays the groundwork.
So how should someone approach answering that?
Be detailed, but keep it clear. Don't just say, oh, I have back problems. Talk about when it started. Has it gotten worse? How often do the symptoms flare up? How severe is the pain? Maybe on a scale.
Give them a clearer picture, maybe with an example.
Sure. So instead of just back pain, you might say something like, well, since my spinal stenosis diagnosis back in 2021, I've had this constant lower back pain. It usually spikes to maybe an 8 out of 10 if I sit for more than, say, 20 minutes.
Okay. That's much more specific.
And crucially, whatever you say needs to line up with what's in your medical records. Consistency is really important.
Got it. So, building on that, the next logical question seems to be, how do your conditions limit your daily activities? This gets into the real-world impact, right?
Precisely. The ALJ needs to understand your functional capacity. What can you actually do on a day-to-day basis, and what can't you do because of your condition?
So you need concrete examples again.
Yes, definitely. Think about everyday things. Personal care, getting dressed, taking a shower, household chores. Can you cook, clean, do the shopping? What about just getting around walking, standing, sitting for periods of time?
Can you give an example of a good answer here?
Someone could say, I really can't stand long enough to cook a full meal anymore. After maybe 10 minutes, the pain in my legs just forces me to sit down. So I have to rely on my family for things like grocery shopping now.
Okay.
Or perhaps my fibromyalgia causes such severe fatigue that I often can't manage basic housework. Even just loading the dishwasher might mean I need to rest for an hour afterwards. The key is honesty, without, exaggerating. Just paint a clear, truthful picture.
Right. Honest, clear, specific. Now, the ALJ also needs to consider your work background to see if other jobs might be possible, which leads to, what is your work history and educational background? How does that play into it?
Well, this helps the judge understand your skills, your experience, and whether any of that could potentially transfer to a different kind of work, maybe something less physically demanding or mentally taxing, depending on your limitations.
So what details do they need?
They'll want to know about the jobs you've held over the last 15 years or so. What were the roles? What did you actually do? What were the physical demands, the mental demands? And importantly, why did you leave those jobs, especially if it was health related?
Add education, too.
Yes, mention your highest level of education, any degrees, any special training or certifications you might have. And if you have gaps in your employment history because of your health, be ready to explain those too.
Okay. And what if you've actually tried to go back to work since your disability started? That seems like it would be important information.
Absolutely. That directly addresses the next common question. Have you tried working since your disability began?
Why is that one so significant?
It tells the ALJ about the severity of your condition and also, frankly, about your motivation to work if you were able to.
So if you did try.
Be prepared to describe it. What job was it? What specific challenges did you face because of your condition? Why couldn't you keep doing it? Be specific about how the symptoms got in the way.
And if you haven't tried.
Then you need to explain why not. Maybe your doctor explicitly advised against it. Or perhaps your limitations just made it clearly impossible from the start.
And honesty is key here too, I assume.
Absolutely vital. The Social Security Administration can and does check your earnings records so they'll know if you've worked. Full transparency is the only way to go.
Makes sense. Okay, moving on to treatment, they'll likely ask, what medications are you taking and what are their side effects? Why focus on the side effects?
Because sometimes the side effects of medication can be just as limiting or even more limiting than the actual condition you're taking them for.
Ah, right, like drowsiness or dizziness.
Exactly. The judge needs the full picture. So list everything you're taking, why you take it, the dosage, and then describe any side effects you experience.
Can you give an example?
Sure. You might say, I take gabapentin for my nerve pain, but honestly, it often makes me feel quite dizzy and sometimes unsteady on my feet. That makes it feel unsafe for me to drive, and it's hard to concentrate for long stretches.
Okay. That connects the medication directly to a functional limitation.
Precisely. And it's always a good idea to bring a written list of your medications with you.
Yeah.
It's easy to forget something under pressure.
Good tip. Now, to get a sense of the day-to-day reality, the ALJ might ask something like, how do you spend a typical day? Seems simple, but I guess it reveals a lot.
It really does. It lets the judge see how your limitations actually play out in real life, outside of specific tasks.
So what kind of details should you include?
Walk them through it from morning to night. When do you get up? How long does it take? Do you need rest periods? What can you actually manage to do? For how long? Do you need help with anything?
Maybe an example.
You could say something like, well, I usually wake up really stiff. It takes me maybe 30 minutes just to get moving properly. I might be able to do some very light tasks around the house for, say, an hour. But then the pain flares up and I absolutely have to go lie down for a couple of hours.
Okay.
And it's also really helpful to mention if your days vary a lot. Talk about what a good day looks like versus a bad day and maybe how often you have those bad days.
That gives a more complete picture, and that leads us to the final big question, the one that sort of sums it all up. Why do you believe you cannot work?
Yeah, this is your chance to really connect all the dots for the ALJ, to clearly state why your specific conditions and limitations prevent you from holding down a job. Any job, really.
So how do you answer that effectively? Not just saying I can't work.
Right. Avoid vague statements. You need to link your specific symptoms directly to job requirements. For instance, my chronic fatigue from fibromyalgia means I just can't sustain concentration for an 8-hour workday. Plus, I need frequent, unpredictable naps, and I often miss days entirely due to pain flare-ups. That makes holding any regular job impossible.
So focus on the impact on work tasks and reliability.
Exactly. Detail how your limitations prevent you from performing essential job functions consistently, day in and day out.
Okay, those are the key questions. Understanding them is huge. To help people feel even more prepared, can you briefly sketch out the typical structure of the hearing itself? What's the flow like?
Sure. It usually starts pretty straightforwardly.
Yeah.
The ALJ will introduce everyone in the room and just briefly explain why you're there.
Okay.
Then it's your turn to testify.
Yeah.
That's when you'll be answering these kinds of questions we've been talking about.
Right.
After you've testified, if there are experts present, like that vocational or medical expert we mentioned, the ALJ will likely ask them some questions for their professional take on things.
And if you have a lawyer,
your attorney will get a chance to ask you some follow-up questions, maybe to clarify points or emphasize something important. They might also make a brief closing statement summarizing why you should be approved.
And then what?
Then the ALJ usually wraps things up. They'll tell you that you won't get a decision right then and there, but that a written decision will be mailed out, usually within maybe 30 to 90 days.
Knowing that timeline helps manage expectations, definitely. So pulling this all together, what are your top tips for someone in Virginia getting ready for their hearing?
Preparation is absolutely key. First, really go through your medical records. Make sure you're familiar with them and that what you plan to say is consistent.
Good point. What else?
Practice your answers. Think through how you'll explain things, focusing on those specific details and examples we talked about.
Maybe even write some things down.
Actually, keeping a simple symptom diary for a few weeks beforehand can be really helpful. It jogs your memory about pain levels, how often symptoms occur, and what you could or couldn't do on certain days. Also, make sure you have your work history clear in your mind. Jobs, dates, duties, why you left.
And on the day itself.
Plan to get there a little early so you're not rushing. Dress respectfully, neat and clean. It just shows you're taking it seriously. All these things help you present your case clearly and build credibility with the judge.
Really solid advice. And for listeners who want to maybe dig even deeper, we found a few extra resources they could check out on their own time.
Yeah, definitely. If you're a visual person, there's a video resource out there called something like Inside an SSD Hearing What to Expect. It apparently gives you a look at the setup and offers tips on testimony, even body language.
Okay. And for audio learners?
There's a podcast resource, I think it's called Expert Insights on SSD Hearing Questions. It features lawyers and even former judges talking strategy for answering these questions. Could be quite useful.
And for someone maybe going it alone without a lawyer?
There are guides available, like one titled How to Prepare for Your SSD Hearing Without a Lawyer. These tend to offer really practical, step-by-step advice on organizing your case and getting ready.
Great options for extra prep. Now, let's quickly tackle a few FAQs we often hear specifically about Virginia hearings. First, how long does an SSD hearing usually take in Virginia? We touched on this, but just to confirm.
Yep, usually 45 to 60 minutes is a good estimate. It can vary, of course, based on complexity if there are witnesses, but the judge has already reviewed your file, so it's mostly focused testimony time.
Okay. Next, what should I bring with me to my SSD hearing?
Definitely bring a photo ID. Bring the hearing notice you got in the mail. That current medication list we talked about is essential, and any new medical records you haven't sent in yet.
What about things like a cane or walker?
Oh, absolutely. If you use any assistive devices like a cane, walker, hearing aids, bring them. They visually demonstrate your limitations right there in the room.
Good point. Here's one people might wonder about. Can I bring someone for support to my hearing in Virginia?
Yes, you can. You can bring a family member or a friend for emotional support. Usually, though, they'll wait outside the hearing room itself, unless they're actually going to testify.
So they don't typically sit in?
Not usually, unless they're a witness. If you have a specific medical need for them to be in the room with you, you should let the hearing office know beforehand.
Okay, good to know. And finally, what if you just blank on an answer? What happens if I can't answer a question during the hearing?
It's perfectly okay. Just say, I don't know, or I can't recall right now. Seriously, it's much better than guessing or making something up. That could hurt your credibility.
And if you don't understand the question,
just politely ask the judge to repeat it or phrase it differently. Don't hesitate to ask for clarification.
This has been incredibly informative. Really understanding these common questions, the process, it has to make a huge difference for anyone facing an SSD hearing in Virginia.
Absolutely. Feeling informed, feeling prepared. It reduces so much anxiety. It lets you focus on clearly explaining your situation. It's such a critical step in getting the benefits you might need.
So as you prepare for your hearing, remember that knowing the process and being able to articulate clearly and specifically how your limitations stop you from working, that's really powerful.
It really empowers you in this crucial process.
Thanks for taking this deep dive with us today.